Oh, great. We have a quorum. All right. I'm going to call this meeting to order. Thanks for letting us know that, sir. A few reminders, as this is a telemeeting, I'm going to ask all members to speak very loudly and clearly, and remind everyone that as an all virtual meeting, in the case of a transmission failure, you need to call 804-382-0381 to alert staff. And if you weren't ready to write that number down, I'm going to give it to you again, 804-382-0381. Another quick reminder, have your microphones on mute when you're not speaking. And we should have, I'm not sure if they're on yet, 2 new board members should be starting today. We have Eric Olson with the Virginia Association of Commonwealth Attorneys and Graven Craig with the Criminal Defense Attorneys. If they're on, welcome to the board, gentlemen. All right. So first order of business is going to be outstanding. First order of business is going to be the adoption for the agenda. You should have received a draft agenda from Ms. Sarkin. Does anyone have any additions or suggested changes to the draft agenda? If anyone does have any changes, again, remember to state your name when you suggest something or make a motion or anything like that. All right, I'm not hearing any changes. Can I have a motion to adopt the draft agenda?
This is Senator Perry. I'd move to adopt the draft agenda.
Senator Perry adopts agenda. Do I have a second?
Officer Evans, second.
Thank you, Officer Evans. We have a motion and a second. I'm going to ask a voice vote. So what I'm going to do is I'm going to ask, especially for things that would clearly are uncontroversial like this, I'm going to ask for an aye vote. And everyone can say aye, or the few people that are on can say aye. When I ask for a nay vote, I'm going to need you to actually take off your mic and let us know if it's a nay vote, or for whatever reason going into the meeting, if you need to abstain. Be very clear after the aye votes, because again, most of these meetings, everything is non-controversial when we pass it. But if you need to say no or abstain, I'm going to ask you to please be very clear about it, because we don't want to mess something up on this telemeeting. All right, all those in favor say aye. Aye.
Aye.
Aye.
Is anyone
Aye.
opposed, or does anyone need to abstain? Please speak clearly. Not hearing any. Okay. That is passed. Approval of the draft minutes for the October 8th meeting of 2025. Next item is approval of the draft minutes. Oh, no, wait, I already got that. Oh, yes. Oh, wait.
And Mr. Chair,
okay, for the October meeting, sorry. Are there any changes in the October meeting that anyone has? Okay, we're going to have to make a motion to approve those. Can I have an approval to adopt the October 8th, 2025 meeting minutes?
This is Senator Perry. I would move that motion.
Thank you, Senator. We have a motion, and can I have a second?
This is Denise Tony. I second.
Motion and a second. Thank you. All those in favor say aye.
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 Are there anyone opposed or anyone need to abstain? All right, that motion passes as well. I'm now going to move on to it's for my turn.
And
I'm
Mr. Chair,
going to move on to the director's report. Director Jackson.
Yes. Chairman Miller, I think Mr. Byrd was trying to say something. I'm not sure what.
yeah, just to remind members to turn their cameras on if they can and leave them on during the meeting.
I think I was supposed to say that. Thank you, Mr. Byrd. That is part of our rules for these meetings.
Great. Thank you. Let me share my presentation.
if you need a couple minutes to go take off your pajamas and get your business suit on, that's fine. Just turn it on as soon as you can.
Great. All right. Thank you, Linda Jackson, Director of the Department of Forensic Science. And I'm pleased to give you a quick update on things going on within the department. The big thing that I've been reporting on for quite some time that we are really in the home stretch is our new central laboratory capital project. The beauty of this is that it is on schedule and it is within budget, which is certainly has been the goal. We are very pleased that we have received the temporary certificate of occupancy, which means that all life safety related items have been completed, and so that staff are able to be within the building. So that we can start working on preparations for moving while they are still finishing the punch list of items that still need to be completed. And so the new address is on the slide of what where the building is located. We will have all new phone numbers. We are still working with Verizon to have those assigned, and certainly we will do some broad-based announcements when those are known, and we'll update the website and all of those good things so that people will understand how and when they can start using those new numbers. And so we are doing a lot of planning right now with this move. That the move has moved back a little bit, and that is not due to the building not being ready. It is due to the fact that the all of our furniture is coming from VCE, or Virginia Correctional Enterprises, and they are backed up with the system furniture, which is basically the cube furniture, which is what we have quite a lot of for our staff. And so those have been coming in a little later than expected. We are now receiving things that we thought that we were going to be receiving in November. And so that has pushed our anticipated move back from what we were originally saying, which was mid-January would be where we started, to more along the lines of late February, early March. And so we are in the procurement process for getting our moving services, and that is moving smoothly. We're getting towards the end of that. And we are working to have planning on having a 5-week phased move-in timeline, so that certain sections or different functions will move in different weeks, so that it hopefully doesn't create a bottleneck and can allow for instruments to still be running until they are ready to be moved and focused on. So certainly we do know that we are not going to have all of our analytical capabilities in at all times, but we are ready to move rush cases around to other laboratories if needed, and that type of thing to be ready. And so the other thing that we were pleased about is that we had money left over at the end of fiscal year 25, and we have been approved to move the majority of that money into this fiscal year so that we can pay for one of the two things, and I'll talk about the other later, but one of the two things is to be able to cover the expanded facilities costs of not only just having a facility that is twice the size of our current facility, but also to maintain our current facility while it is being disposed of, however that ends up happening. And so that was very helpful to us, so that we know that we're going to have these costs. I did want to make just a note about a couple of retirements and new personnel. Brad Jenkins, who has served at the department for 31 years, has retired. He has been the forensic biology program manager. He's the one that I always call on whenever someone asks me a question about DNA testing that is over my head of a drug chemist. And so we certainly appreciate his service to the Commonwealth and wish him well in retirement. And we have hired our previous assistant program manager into the program manager slot for DNA or forensic biology, and that is Elizabeth or Beth Ballard. And so I'm sure that you will get to meet her in April when you're back on site at one of our locations. And also Elise Strobel, who acted as the secretary to this body, has retired, and she was in charge of our federal grants. And so that's a position we're looking for now. And but we wish her well as in addition to Brad. Another thing with our move is that we have been running in our forensic training section that provides training to law enforcement across the state. We have been running 3 sessions of our Forensic Science Academy each year for quite a few years, over 10 years. And because of the move, we are planning to only run 2 sessions of that course in 2026. But we are planning to offer a couple of additional short courses during that time. And so they are working to get those uploaded onto the website, where they are hoping that at least one of those additional short courses can be outside of the Richmond area to serve other parts of the state. We do have, that I've talked about before, a potential piece of legislation that we have received the draft from LIS, and I think it is working through the process within the administration, but it's really a technical change that changes it removes the requirement that the Scientific Advisory Committee meet in the city of Richmond. And it just removes, that location, since our building where we have the meetings is moving to Hanover County. The one other thing that the legislation will do is make it clear that members of this body, the Forensic Science Board, and with the Scientific Advisory Committee, that if there is some reason that someone's term expires and someone has not yet been appointed to fill that position, that the sitting person will maintain their position until someone is appointed to replace them. And this is really so that in the instance of some extenuating circumstances, we don't have an issue where we can't get a quorum because people have rolled off and people have not been appointed to replace them. And so it's really just, and that's using language that's found in other places within the Code of Virginia. So we have continued to make recommendations for the expedited scheduling process through regulation with the Board of Pharmacy. The most recent compounds that we recommended were in the benzodiazepine area. These are things that we have seen in casework generally, and that are similar to other things that are found in the schedules. And so we presented this to the Board of Pharmacy, and it was considered at their December 10th meeting, and it is going through the regulatory process. We have continued to share our controlled substances data with the SUDA platform. And the SUDA platform is the Virginia Substance Use Disorder Analytics platform. It was new in October, and it brings a whole lot of data from various places. So everything from health data, law enforcement, treatment providers, recovery services, all kind of together. And so with our drug data, we have made quite a bit of it available to the public because it is aggregated in a way so that it's not identifiable to any particular individual. And we have controls on so that anything with less than 5 instances is not shown, so that it further aggregates that data. So as of sometime towards the end of December, we had quite a few of our dashboards that they have created within the system made public. And so I've just given you the link to that in case you are interested in looking at that. One of the things that we have not had available before are looking at different combinations of drugs. So, you know, how often are we seeing cocaine mixed with fentanyl and that type of thing. And so, and it's definitely available in being able to look at that data across jurisdictions so that you can really hone in and look and see what that data shows for where you are in the state. An update to the breath alcohol instrument platform coming up with our new instrument. I reported before that we had issued our contract finally with the Draeger company for the Alcotest 9510. And so that is, they are in process now of customizing the instrument to Virginia specifications. We need the instrument to be able to work within how the Code of Virginia and our regulations have the breath program set up for the state. And so we've had folks from Draeger here, and our folks have been meeting with Draeger individuals almost weekly since that contract has been scheduled or signed. And so they are moving forward, and we are expecting in February our first shipment of those instruments. We should receive 2/3 of those instruments in February. And that's when we will be able to start developing the training for the breath test operators. All breath test operators around the state will need to be trained and relicensed on this new instrument. And that will happen kind of in a phased approach because we won't be just replacing all of the instruments at once. We will be doing areas, in a stepwise fashion. And then we will also be developing training that we will be offering to attorneys and judges, and we will have those at our laboratories across the state. The last question that I've been getting about the operator training is, will everyone have to come to Richmond? And the answer is no. That a good portion of that retraining on the new instrument will be online, and then operators will have to go to one of the sites across the state where we do retraining for a short portion of that, where they can actually do the hands-on portion and run the simulated breath tests so that they can be licensed. I've been reporting on pre-log, which will allow for officers to put data into our system about the evidence that they are going to be submitting prior to coming to the laboratory. We are still currently beta testing and updating our materials for the training. The software vendor has made some changes to their system that have required us to change our training. It's actually they've made some updates for things that will be helpful to law enforcement. And so we wanted to make sure that we can, that we have that version updated on our system and have refreshed the training materials that we'd originally put together so that we can utilize those updates. So we'll certainly, as soon as we are ready to move forward on a more global basis, we will be sending out a customer notice that will go statewide. We will also be chatting with the medical examiner's office so that they are prepared as well. We do continue to do some case transfers on a more bulk basis, and those are generally from our firearms section in Western, where we are not doing comparisons currently in Western for firearms. And so those cases are all being distributed across the state to the other laboratories. And we are also transferring some latent print cases from the Northern laboratory as we are still trying to hire folks to fill out that section. For outsourcing to private laboratories, we have already, for this fiscal year, sent all of the cases that we are going to send. I believe anyway, or what we had planned, which was 600 cases that we have sent to Bodie Technology, which is in Lorton, Virginia. And probably about 2/3 of those cases we've received results from, and the others are still in process. We are still paying to have the medical examiner out in our Western lab outsource certain toxicology cases for their death investigations. Until we have 3 people in training in that toxicology section. And so once those folks complete their training, we will dial that back in. And then we have some very limited outsourcing that we are doing to NMS laboratories in Pennsylvania for controlled substances cases. Those are for the edibles where they need a quantitation for the THC level within edibles. So brownies, gummies, that type of thing. To give you a little more information about what's going on with our Western firearms section, I previously reported to the board, and I had notified customers, and we'd just spoken about it, that we are not performing firearms comparisons in the Western laboratory. It has been taken off our scope of accreditation. Our quality investigations in the Western firearms section started with a proficiency test where an examiner did not report the expected results on that test. That examiner retired prior to completing the remediation plan that was part of the corrective action that stemmed from that proficiency test. Also, though, as part of that corrective action, additional case reviews were performed by in-house personnel for cases that had been performed around the time of the proficiency test. However, we decided that we wanted to take one extra step and have a well-qualified outside examiner do an independent examination of the evidence in a few limited cases. So to have a small sample size, but actually let an external examiner look at the evidence independently instead of just reviewing the case files. It took time to establish a contract with a vendor and to get an examiner to come in to Richmond to review the cases, but this was performed just before the holiday. And so we had brought in 6 cases from law enforcement that had been previously worked by that original examiner. And during this quality check by the external examiner, the external examiner came to the same conclusions as the original examiner in 5 of the 6 cases. In the last case, there were items that the original DFS examiner had reported as unsuitable for examination, but the external examiner was able to examine them and draw a conclusion. So due to this inconsistency, we plan to expand our sample size for the quality check and request additional evidence be returned that had this type of unsuitable result. This is not the same issue that was seen in that proficiency test. And so we want to have a larger sample size to be able to evaluate what was going on. We are in process of notifying the Commonwealth's attorney in that one case, and so I don't want to talk about it specifically at this point. But the other thing is that we are doing is that we are in the process of changing our examination protocols to require a verification. So have another examiner look at the evidence and agree when someone is going to consider something unsuitable for examination, so that will be a statewide change. And so that's where we are with that. I'll continue to report after we have continued our investigation. I did attend as the member representing the Forensic Science Board to the National Association of Forensic Science Boards, which I like to call the Board of Boards. They had a conference at the University of New Haven in October, and I did go to that, and just wanted to let you know kind of what was discussed. If anyone is interested in going in the future, it's certainly open to anyone from a board across the country. So my key takeaways, we heard from quite a few different states and different things about their oversight bodies that they have. There are people that have boards, advisory committees, commissions, all sorts of different ways of naming and structuring those. We listened to folks from Connecticut, from Maryland, Massachusetts, Texas, and Colorado. We also heard from people from New Jersey and Oregon that are trying to start some type of oversight, and what their process has been. Virginia is different than all of the others that we heard from, and that we have the two different bodies, one being more scientifically based, one being more administratively based, policy based. Most seem to have, just one body. We heard a legal update that focused on Smith v. Arizona, which was interesting because the panel included the judge from Arizona that had originally heard the case. And so that was interesting. And there was talks on newer technologies such as rapid DNA, forensic investigative genetic genealogy, and the use of artificial intelligence, and whether those were things, how they were fitting into the oversight bodies of the folks that were speaking. So happy to talk to anybody about any of that. And I will certainly let everybody know they're going to release the proceedings where they will have a summary of, a pretty detailed summary of all of the different presentations. And so I will share that as soon as it is available. So our case statistics, we just had our statistics come out yesterday. And so I just have provided the annual statistics for each of the sections. In general, all the disciplines had a decrease in submissions for calendar year 25 in relation to calendar year 24. That is in line with what we saw with the fiscal year. So, it's just off 6 months. And at the time when we saw the reduction at the fiscal year, I had reached out, and it seemed in line, our reduction seemed directly in line with the reduction in the crime statistics. And so since we're a support agency, that made perfect sense. There were both increases and decreases in our ending backlogs, but pretty much all disciplines except for toxicology did have an increase in the average turnaround times of cases. A lot of times there are times when the turnaround times will start increasing before they get better, when we are digging ourselves out of a hole, because you end up doing a bunch of older cases and it makes your statistics look worse. But certainly we are continuing to work on forensic biology and firearms with those more extended timelines. So just an update for budget and resources. Our current staffing level, we have 329 general funded classified positions and 19 non-general funded. Those are paid for by federal grants. Currently, all of our federal grants are still they're still continued, and we have not had grants where we had them in the past that have not been offered for the next year. We are not sure hearing nationally what's going to happen for the year after that. So that will be something certainly to keep an eye on, with 19 of our staff members being paid off of grant funds. As I mentioned before, we did get approved to carry forward $5.4 million for the paying for those breath alcohol instruments, since those funds had been earmarked basically for that purchase, and the contract just took a long time and the procurement took a long time, so that we were not able to get them in-house to pay for them before the end of the last fiscal year. So that is wonderful. And again, $2.1 million to be able to cover our transition costs for moving to the new central lab and maintaining the facilities. We have not gotten additional money put into our budget to cover the expanded costs on a permanent basis for the new facility that, is twice the square footage. And so therefore the utilities costs will certainly also be higher. But that's because it's really hard for us to estimate how much that will really be. And so this carryover money will give us a good, hopefully, way to see what the cost will be for 6 months and be able to, make estimations from that point. So with the governor's introduced budgets, the only thing that there are certainly a bunch of technical changes that were made to every agency. The only change that was non-technical was that it did include 2 additional forensic scientist positions for DNA analysis in the new central laboratory. And so those positions are noted there. And so that is something that we had worked with DPV in the past, where when we did our estimation last year, really it looked like we needed 6 additional people, but we really didn't have anywhere to put 6 additional people. So we were given 2 positions last year and 2 positions again this year as we are moving into the new facility. And then we'll continue to evaluate where we need to be based on submissions. The last thing that we had talked about at several different meetings was the fact that we are having difficulty certainly recruiting qualified people in our northern laboratory, and we've had some turnover issues in our northern laboratory, and that we did the compensation study in-house. And it was very clear that all of our examiner type minimum salaries and actual salaries in Northern Lab are below market. And so those changes need to be done through the budgeting process, but nothing was included in the governor's introduced budget. And so just since we had talked about that several times, I just wanted to point that out. And that was all I had, and happy to answer any questions now or in the future.
Thank you, Director. Does anyone have any questions? All right, we're going to move on to old business. Before we get started, we're going to have a 3-part presentation between our DFS staff and members of the Crime Commission on the Mary Jane Burton case. And I know there's several members of this board that are very interested in the status of this case and everything else that goes along with it. What I'm going to ask is that if you have questions, let's wait until all 3 people have given their presentation. And the reason I'm saying that is I spoke with members of the Crime Commission and staff previously, and they said that many of the questions that you may come up with during this presentation will likely be answered by a couple of the follow-up presenters, if that makes sense. So if you have questions, please write them down. Those questions may be answered and likely will be answered as the presentation keeps moving forward. And if those questions are not answered, we will go ahead and do the questions at the very end. So that said, we're gonna go ahead and start with Dr. Arrington with the Crime Commission, and she's going to hand it off to Amy Jenkins, who will then hand it off to Mrs. Rowe. Dr. Arrington.
Good morning, Mr. Chair and members of the board. Can everyone hear me okay and see the presentation?
I could hear you, yes.
Okay, perfect. As Mr. Chair indicated, this is part 1 of a 3-part presentation relating to the work of Mary Jane Burton at DFS. And my presentation will provide the status of the case file review based on the 2024 budget language. As you recall, the budget language directs the Crime Commission to determine the scope of Ms. Burton's cases across the following 3 categories. First, the total number of cases worked by Ms. Burton that include at least one named suspect. Second, the total named suspects convicted of an offense in a case worked by Ms. Burton and whether those individuals are now incarcerated under DOC supervision, deceased or executed. And third, the total number of cases where Ms. Burton testified in court. And probably the most significant update since we last presented to you in October is the status of the physical case file review. At our last meeting, we had reviewed 68% of Ms. Burton's cases. Now we are pleased to report that we have completed reviewing 92% of all known cases worked by Ms. Burton. So that's almost 7,000 cases reviewed and cross-validated. And we really want to thank the State Library of Virginia for expediting the delivery of numerous batches of boxes for us to review after the last meeting. Also, during the course of this case file review, we've thus far identified 186 cases with indication of testimony by Ms. Burton, as well as an additional 550 named suspects. We also wanted to share a couple of visuals to show the nature of the physical case file review. The picture on the left shows what a normal batch of boxes looks like. We have reviewed hundreds of these boxes, but what's important to note is how the material within each of these boxes can vary so widely. For example, as seen on the picture on the right, we may really luck out and have a box like this that contains all Mary Jane Burton case files. But far more frequently, we have a box like this that includes a range of lab case files worked by various forensic examiners, and we have to go through and extract anywhere from 1 case worked by Ms. Burton to over 100 cases. And then it must be mentioned that not all of Ms. Burton's case files are created equal. Some of the lab case files include 2 sheets, simply comprised of the request for lab examination and the certificate of analysis, whereas others contain thousands of pages. So with those visuals in mind, here is the current status of work on the 2024 budget language. So the total number of cases is seen at the top in the red box at around 7,500. And at this point in time, 4,743 named suspects have been identified in the cases we've reviewed thus far, as seen in the dark blue box on the right. The green boxes represent the conviction status of these named suspects. And thus far, staff has confirmed 1,262 named suspects with a conviction, 906 named suspects with a non-conviction, which includes dispositions such as dismissed, null prost, not guilty, etc. And then the remaining named suspects still need to have their conviction status verified. Finally, the orange boxes on the bottom move away from the concept of named suspects to the concept of unique individuals. And as of today, we know the status of around half of these unique individuals, with 108 who are currently incarcerated, 54 who are under DOC supervision, 408 who are deceased, 8 who are executed, and 11 who were exonerated. And your handout provides more detailed information on each of these classifications. And I do want to mention that in terms of the orange box at the bottom, various measures have already been undertaken to assist these convicted individuals identified. Specifically, DFS has notified all individuals who have been identified as being incarcerated or under DOC supervision. Second, the UVA Innocence Project has been provided with a list of individuals identified as being incarcerated, along with a scanned copy of their full DFS lab file to incorporate in their review and assignment of individual cases to pro bono attorneys. And finally, the Mid-Atlantic Innocence Project has conducted an independent review of all cases where an individual was executed. So in conclusion, to complete the directives of the 2024 budget language, staff will review the remaining 626 or 8% of cases where Ms. Burton was the forensic examiner, and then staff will research and verify the conviction status of any outstanding or additional named suspects identified as the review is finalized. And with that, I will now turn the discussion over to Ms. Jenkins at DFS, who will be presenting next.
Good morning. Hopefully everybody can see my presentation at this point in time and can hear me as well. And Christina's shaking her head so that I know we're in good shape. Have been asked to, let me hang on a second. I wanted to thank Senator Perry as well for her assistance with the Library of Virginia and the State Records Center. She offered to provide any assistance, and that really greased the wheels as far as getting the additional boxes pulled by SRC, as well as our supervising legal assistant here, Jess Norton, who oversaw all of the boxes coming in for the Crime Commission, which is no small feat, as you all are aware. And I don't think I've got the right screen being shared, so I'm going to stop sharing and try one more time. Hopefully that is correct. There we go. I wanted to go back and kind of do some of the build up to where we are with the budget language that Christina and staff from BSCC has been working on. Just because we have some new board members that may not be as familiar with how this all came to be, and the fact that it was put before the Scientific Advisory Committee for review, and that subcommittee that was established. We began receiving inquiries from the podcasters for the Admissible Shreds of Evidence podcast in 2019. And they were requesting at that time various records through FOIA, mostly focused on personnel files for the individuals that were named in the podcast, including Mary Jane Burton. In 2022, in February, a podcast reporter reached out to Director Jackson and asked for an interview. And the interview was to discuss the department's mission, its case reviews, the quality assurance program, and then they also added a discussion or a request regarding Burton's role, legacy, and reputation with the department. The director and Brad Jenkins, who was then the forensic biology program manager, agreed to the interview with the understanding that they didn't have anything to provide as far as Burton's role, legacy, and reputation, because they had not worked with her and were not familiar with that. It was at that time that the interviewer indicated that they had documentation that Burton had changed results. That was not an in-person interview. It was a virtual interview. Those results were shown over camera, and at that time, we had no information regarding those allegations and no response. We subsequently immediately asked for the documents that were referenced by the reporter. The next month, the VPM producer responded that they were not going to provide access to the documents and at that time. We then, in February of 2023, learned about the release of the initial episodes of the podcast, and again asked for documentation. In May of 2023, the podcast reporter indicated that they would exchange the documents for an on-the-record interview, which was declined by the department. And then in July, after the final airing of the first season of the podcast, some of the requested documentation was provided. It was clear it was not all of the documentation that was referenced in the podcast. The podcast repeatedly referred to a box of documents and we received basically 5 cases, the documentation regarding 5 individual cases that Burton had worked in July of 2023. We again asked for all of the reference documents, but given what had been provided, the director made the referral to the Scientific Advisory Committee in August of 2023 for their review. Only after that initial meeting of the SAC subcommittee did the podcast reporter provide the rest of the documentation. But they indicated at that time that in July, they had really shared everything they had with identified issues that they had in their possession. The additional information didn't add much to what had already been placed in front of the SAC review subcommittee. So I apologize. The department has a duty to review received complaints under its accreditation requirements. And that was the nature of what Director Jackson was doing, was referring that complaint and the allegations that were there in the podcast to the Scientific Advisory Committee in order to have them review the analytical work, reports, and conclusions that have been made by Ms. Burton in those cases. And we contacted Kathleen Corrado, who was the current chair of the SAC. The subcommittee was established, and they began the review. We set up the first meeting in October. So there's the timeline of the review. The first meeting was a general review of the allegations, a review of serology in general by one of our department serologists that was still employed at the time, historical procedures that were employed or were involved at the time in the 70s. And then the second meeting was really more of a focus of a review of the cases provided by VPM. Other case reviews that I'm going to touch on in a little bit, at least as far as the post-conviction testing project. And finally, a review of the Marvin Grimm case that was percolating through the courts and was in front of the Virginia Court of Appeals at that time on a writ of actual innocence. The final meeting was an approval of the proposed notification letters and then a briefing on what was pending in front of the General Assembly as proposed budget language for the review that Christina just addressed. In looking at the actual allegations on the 5 cases that came in, I've highlighted for you the different types of cases that were involved and what specifically was alleged based on the documentation that was provided by the podcast reporters when they provided that information. In initially looking at these, we did a whole document that is available on the website tied to that January meeting as materials, which went through all of the documentation that was provided, and then what the end results of these cases were, and had the SAC review all of those, the SAC subcommittee review all of that information to determine what was concerning for them. A lot was made about the lack of origin testing to rule out non-human, but that was not a standard thing at that time. That and CAT case, as it was referred to on the podcast, really was not lost because of the lack of origin testing. It was the first case in Virginia dealing with inadmissible nonverbal hearsay. It went up to the Supreme Court of Virginia, and the case was lost because of that evidentiary issue. The fact that she had not done origin testing, she conceded in cross-examination, and it really, even though the press honed in on that, it was not in legal terms the reason why there was no convictions in that homicide case. The Deer case, there was no resulting conviction. That was a case where a hunter was shot in the woods. It was a situation where really serology would not have been probative given the factual allegations. And she did subsequently do origin testing, and there was some documentation about positive results for deer and ruminant in the RFLE, but there was no worksheet. But that was not required at the time. There's never been a conviction for that case. The inmate felony assault case, there was actually a mix of individuals, not just Mary Jane Burton, involved in the testing in that case. And there was no subsequent conviction. And the testing was done on the suspect's clothes, on whether or not there was blood typing related to the victim on the suspect's clothes. The rape case was the one case that had changes in results that were concerning, I think, to the SAC subcommittee, because there did not seem to be adequate explanation about why that was changed. Subsequently, there was a conviction for the two co-defendants in that case for fornication, and a $100 fine was imposed. It was not PC project eligible due to that, which we'll talk about in a little bit. The one suspect was determined to be deceased at the time of the PC project, and the other we were unable to locate during the PC project. And the final homicide case, the allegations were records showing discrepancies and reporting a type that did not exist. This was a transfusion blood case, which does produce some odd results with serology. And the PC project subsequently confirmed the results that were reported through DNA testing. So as the SAC reviewed all of the allegations, the main concerns were the Winston Scott exoneration, which was a case that, and I know Sean Armbrust is on the call and is handled this case, so is very familiar with it. But there were some changed results in that case that was a subsequent exoneration that was also very concerning to the SAC subcommittee. And then what was reported regarding the Marvin Grimm case, which focused on the fact that there were sperm identified by Ms. Burton that were not subsequently seen in any analysis of that evidence or by either DFS or private labs. The actual serology results should have been exonerating to Mr. Grimm, but Ms. Burton did not testify. Mr. Grimm pled to that charge. And then also dealing with the hair analysis. So there were 8 hairs that were attributed to the victim that were located in Mr. Grimm's possessions or property, and subsequent MINO DNA testing on those hairs determined that they actually had come from 6 other individuals and not from the child victim in that case. Based on all those concerns, both the rape case that had been provided by VPM, by the Scott case and the Grimm case, the SAC determined that notification should be made to the parties regarding the concerns with Ms. Burton's work, although they weren't able to attribute any kind of intent to the errors that they saw or the issues they saw with Ms. Burton's work. They still felt it was significant enough to require the department to notify the parties. We were directed to draft notifications to prosecutors, law enforcement, and to convicted individuals, that the parties could request us to review those cases or a case, and the parties could request DNA testing if the evidence was still available. And this was in order to comply with DFS also has the accreditation requirement to notify and correct any issues with our analyses. So the notifications were made to law enforcement and to the Commonwealth's attorneys. We're working on the notifications to affected individuals, and that offer to, while we can't correct because we don't have the ability to go back and retest the evidence if the evidence is not provided to us, that we would conduct testing if the evidence was still available. So the law enforcement notifications went out in June of 2024. Director Jackson and I and Ms. Howard with the Crime Commission have done an extraordinary amount of outreach as well to the Commonwealth's attorneys, to the chiefs, to the sheriffs, and to the clerks to notify them about the issues with Ms. Burton's work, to ask them to provide information regarding conviction status on these cases. And there's also been the outreach through the Department of Corrections. The department's initial concerns were with those that were currently incarcerated and trying to get information to them as soon as possible. So notification was sent out through DOC, through the tablets of the inmates to let them know of the review, where they could write to me if they had, if their case was worked by Burton, or if they had questions about whether their case was worked by Burton, and that we would flag them for the UBA IP portion of the review if they were still incarcerated on a case that Ms. Burton had worked, or had that in any point in time had a case that Ms. Burton had worked. The department was also significantly concerned about the executed cases, and I conducted a review of the executed cases. We also asked Sean Armbrust, who, as indicated, I know is here. I'm going to let her speak. I think she intends to speak as part of the public comment to review those execution cases to make sure we did not need to do any follow-up on those cases, or what Ms. Burton's role was in those cases. We're currently making those notifications to the affected individuals. As I pointed out, the issues in the past, we have to have the conviction information. We can't send, a notification to someone when we're not certain if they have been convicted of the offense. There's going to be a number of offenses where there were no resulting convictions in this instance. We have to have enough personal identifiable information. What we typically have in these files, if we don't have conviction information, is a name, and probably not a full name, and likely a age as assessed by law enforcement. We did not require in the 70s dates of birth and social security numbers, and we do not have that on the request for laboratory exams that come in. Usually the dates of birth are located on the court orders once those are received, and maybe a social security number. And then we have to locate valid addresses through non-law enforcement databases. We don't have access to law enforcement databases. We're not law enforcement. So we have to utilize LexisNexis and public records in order to be able to try to locate valid addresses for those. We have gotten notifications to all of the incarcerated individuals, and as Christina said, also to those that are currently being actively supervised by probation and parole. The focus now is on the non-incarcerated individuals. And what we have indicated to them is that, the work of Ms. Burton has been questioned. I have to be careful and indicate that we can't provide any legal advice, and they should seek an attorney's advice regarding available options, that we will provide forensic analysis results to the affected individual, and that we would discuss any testing options available if evidence is located, and we would either need the party to agree to DNA testing, or the parties to agree to DNA testing, or it would need to be ordered by the court. DFS doesn't have any independent ability to ask for evidence to be resubmitted, or require the evidence to be resubmitted in these cases. It's got to be done either through the agreement of the parties or through an order of the court. There is significant overlap with these cases with the post-conviction testing project. And for those that weren't here for that, and I'll tell you that I was only involved on the fringes. It was wrapping as I was coming into the department, and it was not part of my assigned duties. But it was a full-scale review of serology files that were worked from 1973 to 1988. Where Ms. Burton and other staff members retained swabs and cuttings in the case file. There is a long overview of this project in the Forensic Science Board's reports that are available online that you can review if you have more interest in this project. But the focus was on testing of these cases where we had taped down swabs and cuttings. The initial testing was for violent felony offenses based on the grant provided by the federal government. And testing was conducted in about 860 cases. In 2008, budget language was added requiring the board to notify all convicted defendants whose case files were found to contain swabs and cuttings that the evidence existed and was available for testing so that they could request that if they wanted. And at that point in time, a notification subcommittee of the board was established. Further reviews of the results on the 860 cases were conducted, where the Crime Commission recommended DFS retest inconclusive cases if specific instances were met, if the evidence was probative, if there was sperm or seminal fluid present, if the defendant was incarcerated. So an additional 34 cases were recommended for additional testing by the notification subcommittee at that point in time. It was discussed about notifying the next of kin for any deceased eliminated defendants. As we'll discuss further, eliminated does not always mean exonerated. In particular, serology was done on like the pool of blood that was under the victim, where the elimination of the defendant from that pool of blood would not necessarily be probative. But there was a review of the probative value of that evidence for 19 deceased eliminated individuals, and notification was attempted on the next of kin for 11 individuals, and the Crime Commission successfully notified 8 of the 11 defendants next of kin in those instances. In 2015, in order to wrap the notification project, BSCC dedicated 2 staff members to the project. And in 2016, the Crime Commission worked with DFS to identify the need known cases. Need known cases are when a reference sample is needed either for the victim or the defendant or both, in order for our scientific staff to come to conclusions on the DNA profile that was developed from the evidence. And we have made efforts, and the Crime Commission has made efforts to notify those individuals, and at least 3 separate attempts have been made for those individuals as well. So there are exonerations that will be reviewed by the independent panel. There were 13 total individuals that were exonerated because of testing associated with the PC project, either in advance of the PC project that kind of was the impetus for the PC project, or as part of that PC project. Mary Jane performed about analysis in about 9 of those cases. We can confirm she may have performed serology in a 10th case, but that case file has been expunged in its entirety, or at least the serology documentation has been expunged from the case file. Why, I'm not certain. I'm sure it was to comply with the expungement, but we could have simply expunged the name as opposed to expunging the serology documentation in full. I've looked at these exonerations. The Innocence Project or the National Registry of Exonerations have published contributing factors to wrongful convictions in these cases. And in 3 of those cases, false or misleading forensic evidence has been indicated. You know, I can speculate that a lot of that has to do with masking, which is a phenomenon in serology, which I think is the subject of discussion nationally on the validity of masking. Certainly, you know, I think that needs to be thoroughly investigated by the independent panel, and the serologist that is appointed would have knowledge of that information. One of the cases, Winston Scott, was one of the cases that was of concern for the SAC review subcommittee. As far as the executed cases, I've provided you with the names of those individuals, last names of those individuals, and the PC testing in general, if PC testing was conducted. As you can see, there were a number of cases where the individual could not be eliminated as a result of this subsequent DNA testing that was done by DFS. There was a familial hit in a 4th case. or we have not, or we needed a full sample from the defendant in order to come to complete conclusions on a foreign DNA profile developed. But there was a full confession in that case. In addition, there are two where no serology takedowns were there, no PC testing was conducted. In the Correll case, the serology results were not informative and not part of the conviction information. And in the Clanton case, the defendant was actually found under the victim's bed when the police responded to the scene. So DFS, it was my conclusion in reviewing all of these that Burton's work did not contribute to a wrongful conviction for any of these 8 individuals. And I think Ms. Armbrust, I won't speak for her, she can share her thoughts when we get there. I also took an opportunity to kind of break down the incarcerated cases for you into various pools so that you can see how these individuals, are incarcerated on cases, whether they're currently serving the term for the Mary Jane Burton offense, or they've completed that term for the Mary Jane Burton offense and are being held on new offenses. There's obviously some uncertainty on a couple of these, as it's not always clear for particular victims. The orders do not have victims' names. We typically need the indictments for those, or we need additional information from the police or law enforcement. So we're still having to dig on those cases to determine whether they're serving term for the MJB offense or they've completed it. Serving the term for the MJB offense can also include parole revocations for various reasons, both technical violations and additional convictions. This also gives you an idea, this breakout about the types or the most serious offenses. Many of these individuals are held on multiple offenses. For instance, you'd have a B&E with a rape, with an abduction, with a robbery, perhaps. I've tried to determine the most serious offense for each of these individuals and provide you with that breakout. As you can see, 84% consist of either murder or rape convictions. And finally, the PC project status and overlaying the incarcerated individuals' cases with the results from the PC project. Here you see the different breakouts on whether or not they were in the PC project, and if they were in the PC project, what the results were. Indicated means that the PC results implicate the individual. Eliminated would mean that the individual was eliminated from the sample from the tape down swab or cutting. That does not necessarily mean exonerated. It is going to depend on the facts and circumstances of the crime. As I indicated earlier, being eliminated from the pool of blood under the victim would not be an exoneration finding. Need known means that we need a reference sample either from the defendant or from the victim in that instance. Inconclusive does not mean, typically means when you're looking at these that there's no DNA results or that there's no DNA types of value that were developed from the tape down swabs. If you are aware of the circumstances of the tape down swabs, this is swabs and cuttings that were taped down using regular tape onto a worksheet and put into a file. They have degraded or they have been, the subject of contamination, so to speak, in the file because they've been handled. So they're not been preserved the way that DNA evidence should be retained. And so often there are no DNA results or DNA types of value developed from the tape down swabs. The not part of the PC project would indicate in this instance that there are no tape down swabs. There were not always instances where she would tape down swabs or cuttings in the file. We've tried, and I've talked with staff to try to figure out if there were any reasons why she would or would not. It's not really clear to either myself or staff as to what would trigger that to occur. Testing underway, we have about 11 cases right now where we have determined a changed conviction status based on additional information we've received from law enforcement or additional information received from DOC or from the parole board. And we have undertaken testing of those tape down swabs in those cases. And that will be released as soon as the testing is completed, which I would think would be in the next couple of months. So that kind of gives you an idea of where we are and what the overlay of the PC project is. And clearly, there's a lot of overlay between the defendants that were in the PC project and the Mary Jane Burton incarcerated individuals. So going forward, we'll continue to utilize the public records to try to locate conviction status. Once we receive the conviction status from the Virginia State Crime Commission, we're providing information on whether, if we're able to determine that an individual is deceased for the Crime Commission, Heather Ford, who was hired as a result of the General Assembly granting the additional position to DFS, has been working diligently on reviewing cases and trying to see if we can locate these individuals. And if we are able to determine that they're deceased, due diligence would require us to record how we have come to that conclusion. We will return, or try a different address if the letter is returned until we have gotten through all viable options as far as addresses. A lot of times we just don't have enough PII to locate these individuals. If you have a John Smith that was convicted who is age 21, we're not going to be able to locate those individuals. It's just not going to be feasible. And we're going to continue until all of the cases have been reviewed and we've gotten all the conviction information and we've exhausted all leads to try to notify the affected individuals. If the independent panel makes additional findings, or if any change is made to the status of these individuals as far as any grant by the legislature for any type of relief or ability to go in front of courts for review of these cases, we'll have the ability to provide additional notifications to affected individuals going forward. So with that, I will turn it over to Tracy Rowe to talk about the independent panel more.
Okay, can everybody see the presentation and hear me okay?
Yes.
I can hear you.
All right. Good morning, Mr. Chair and members of the Forensic Science Board. The purpose of this presentation is to provide an update on the Mary Jane Burton Review Panel that was created by 2025 legislation. This legislation directs the Crime Commission to designate a panel to review cases where Ms. Burton was the forensic examiner and the case resulted in a conviction of an individual who is now incarcerated, was executed, or was exonerated, or in cases where Ms. Burton testified, regardless of the final case disposition. The review panel will evaluate the accuracy of Ms. Burton's testing, analysis, and testimony, and determine, if possible, whether she engaged in a pattern of misconduct. However, it is important to note that this review panel is not tasked with determining actual innocence on any individual case, as that requires a finding by the court. To date, 314 cases have been identified for review to the panel. However, additional cases will likely be identified as the case file review is finalized. The review panel will consist of a Commonwealth's attorney, a public defender, a felony certified court-appointed criminal defense attorney, a retired circuit court judge, a representative from the Office of the Attorney General, the executive director of the Mid-Atlantic Innocence Project, and an independent serologist. The chair of the Crime Commission, Delegate Herring, appointed Delegate Hope and Senator Peake to serve on the review panel subcommittee to develop an application process and provide guidance on logistics for the panel. The application process will begin this month. Staff is working with various entities to notify eligible individuals of the application process. The full Crime Commission will designate members of the panel. Crime Commission staff will provide administrative support to the panel. Staff is currently assisting with the application process and has begun obtaining records from the courts, law enforcement, and Commonwealth's attorneys, which will be provided to the review panel and to the UVA Innocence Project. Staff will also be reviewing those records to prioritize cases for the panel to review. Finally, staff will be coordinating other logistics, such as meetings of the review panel. Mr. Chair, this concludes the series of presentations on Ms. Burton, and we are happy to answer any questions at this time.
Mr. Chair, I think you're muted.
You didn't think I was muted. I was muted. I want to thank the Crime Commission and Ms. Jenkins from DFS for such a detailed presentation on the Mary Jane Burton case. I think that brings us up to speed really well. All right, we're going to move on to new business, and I'm going to call on Ms. Jenkins again to give us an update on 2026 amendments to the regs.
Excuse me, Mr. Chair, this is Theo Samos. Can y'all hear me?
I can hear you.
Good morning, everyone. Just really briefly, and I'm so sorry, but just as we went to our third speaker, I had a work call that I took, so I muted the my mouse thing here, and I couldn't hear. So the discussion was put up there. Are we now having a discussion, or is this an opportunity to talk about a question or an observation we have on the presentation? Did I miss that opportunity?
No, if you have a question, go ahead, Ms. Stamos.
Just two things, and I guess we're going to hear from Sean Armbrust, which I'm happy to hear, but as a member, albeit I'll be outgoing member of the Crime Commission, in the last meeting that we had, there was mention made by both Chair Herring and I believe another member of the Crime Commission talking about specifically the 8 cases that where individuals were executed and involved in Mary Jane Burton review. And I want to make sure that it's known to everyone here and also publicly, and I know Sean, I believe, will restate that the Mid-Atlantic Innocence Project looked at all those 8 executions and determined that there was no erroneous testimony by Mary Jane Burton that led to these individuals being executed. And I think even more affirmatively, none of those individuals who were executed were wrongly executed, that they were the evidence that supplied the basis of their convictions was sufficient and beyond a reasonable doubt. So I think it's important for the public to know that, because that's clearly a concern that anyone in the general public would have about what happened and what transpired involving testing by Mary Jane Burton. And I also just wanted to make a point that I think Amy mentioned, that that the studies that were done and all of the reviews that have been done thus far, that they couldn't attribute a particular motive or intent by Miss Burton in any erroneous conclusions that she came to. And I think that's important as well, because there was a previous comment by Senator Surivel at a Crime Commission meeting that Miss Burton was motivated by that she was a bigot and a racist. And as I understand it, there is, I mean, whatever she was doing, there is no affirmative evidence that she was motivated by racial animus. And I make that point because I think it's important for the public to know that. I mean, the woman is dead. She can't defend herself. What she did and why she did it, we're looking into that. But I think it's important for the public and this body, as well as the Crime Commission, to be made aware of that. So I just wanted to make those 2 points.
All right. Thank you, Ms. Stamos. Okay, Ms. Jenkins, do you want to go ahead with the amendments to the regs?
Yes, sir. So I had forwarded out, or I think Ms. Sorokin, I'm mispronouncing her name, I'll get it right at some point in time. Farrell had sent out the proposed amendments that are fast-tracked, recommended for the regulations dealing with our move to the Hanover facility. Previously, both of these regs were dealing with 6 VAC 40-30-30 and 6 VAC 40-30-50, or 40-50-30 rather, that deal with the request for evaluation that should be submitted by manufacturers who want to have their field tests submitted, either marijuana field test under 40-50-30 or in general chemical field tests or mobile instruments under 40-30-30. And the submission of those requests to the director of the department. We put the address in on this when they were originally drafted, and now the address will be incorrect. My thought process for the board was simply removing the address from the reg. Certainly manufacturers are on our website looking for the information as far as the submission, rather than having to go back in and change this, as we're seeing with the SAC and other legislative issues that we have to change the address or change the locality within statutes. We might as well just delete it and indicate that the request can be forwarded to the director, and they can request that information through the website for that information address. So that would be what I would propose. I think it meets the criteria for fast track. It's not going to be any type of issue regarding the change. And I would ask the board for a vote to approve these changes in advance of the move to Hanover.
Thank you, Counselor. Does anyone have a question for Counselor Jenkins on the changes to the regs here? Okay, I'm going to ask for a motion to adopt the amendments. Come on, Senator Perry, I'm counting on you.
Senator Perry, moving to adopt them.
Thank you. We have a motion to adopt the regulations. Can I have a second?
I'll second.
And we have a second. Ladies and gentlemen, be ready to turn your mic on. Unlike other votes, we're going to have a roll call vote on this one because it is changing regulations. It's not just, kind of at this meeting level type of vote. So staff is going to go ahead and move forward with a roll call vote.
All right, thank you. So I am going to call Mr. Evans.
I vote aye.
And if you're okay, Mr. Craig,
Aye.
Dr. Gormley,
Aye.
Mr. Hade,
Aye.
Ms. Sterling,
Aye.
Ms. Howard,
Aye.
Ms. Jurin,
Aye.
Mr. Maha, I'm sorry, Dr. Maha,
Aye.
Mr. Myers,
Aye.
Mr. Miller,
Aye.
Mr. Olson,
Aye.
Ms. Perry,
Aye.
Ms. Tony,
Aye.
Ms. Stamos.
Aye.
And I have Ms. Watts. You responded in Teams. Thank you.
Thank you.
Okay, could you please announce the result of the vote?
All in favor.
Thank you very much. Moving on to our next section will be public comment. Do we have anyone here that would like to make a public comment? Please raise your hand. There we go. All right. I'm going to call on from the public, Sean Ambrust from, I believe, the Innocence Project.
Yes, thank you, Chairman Miller,
Yes,
and
ma'am.
thanks to all of you for letting me speak today. I want to start by complimenting Director Jackson and the lab. I think, as an innocence organization, one of the things we do is point out a lot of problems in the criminal legal system that lead to wrongful convictions. And we don't do that because we just love to be critical or because we expect perfection, but we do it because we hope people and institutions can learn from errors. And to me, this meeting today was just an incredible example of how the department has learned from errors. If you look at the way the department is responding to the issues with firearms comparisons in the Western Laboratory, if you look at the way the department is handling the current Mary Jane Burton reviews, it's an incredible example of learning from past mistakes. And I think people who are in these roles 40 years from now aren't going to be doing a lot of what we were talking about today. So kudos there. But specifically, I was kind of asked to speak today about the issue of whether Mary Jane Burton's work and testimony might have led to the execution of an innocent person in Virginia. I want to say that, I am personally opposed to the death penalty. So, speaking from my current position, I don't think any of the 8 people executed should have been executed because I don't believe in the death penalty. But the question is whether Mary Jane Burton's testimony led to the execution of an innocent person. And as Ms. Jenkins said, based on my review, I do not believe that to be the case. Of the 8 individuals who were executed and for whom Mary Jane Burton was in some way, shape, or form potentially involved in their cases, in 4 of those cases, post-conviction DNA testing ultimately proved that the individuals convicted were in fact the correct individuals. And in the other 4 cases, identity and or presence at the scene just weren't issues in those cases. So, in one of them, I don't believe Ms. Burton even provided testimony. And in the other 3, the serology testing and post-conviction DNA testing wouldn't be terribly germane to guilt or innocence. As someone who frequently criticizes the criminal legal system, I have issues with some of the convictions in those cases. They don't stem from Mary Jane Burton's work. So I just want to be clear about the limitations of what I'm saying, but also very clear that, as it relates to her work, I do not personally believe, based on multiple decades of experience doing this work, that her work led to a wrongful execution. So for people who have been concerned about that, not that I'm saying Virginia has never executed an innocent person, I'm saying that this did not cause it. So I'm happy to answer questions people have about the reviews, which I admittedly did quite a while ago. But otherwise, thank you again to this body and to the department for the incredible work on this.
Thank you, Ms. Armburst. I appreciate that. During public speaking time is actually not a proper meeting form to engage in back and forth. So I would ask if any members of the board have questions of the Innocence Project to please shoot you an email. Ms. Armburst, would you provide your email or phone number or what you'd like to provide in case members of this board would like to have correspondence with you or more information on your thoughts?
Yes, I just dropped my email in the chat. So if people have follow-up questions, I am happy to answer.
Excellent. Thank you so much, ma'am. We appreciate your presence here today.
Thank you.
Are there any more members of the public who would like to address the Forensic Science Board? Please speak up or hit the raise hand tab. Anyone at all? I don't see anyone else from the public wishing to comment. So now I'm going to confirm the next meeting date of the Forensic Science Board will be on April 22nd, 2026, same bat time, same bat location, right there in Richmond. So everyone, please put that in your calendar, April 22nd, 9:30. That concludes the agenda for today. Can I have a motion to adjourn the meeting?
This is Senator Perry, so moved.
Excellent. Thank you, Senator Perry. It's the best motion of the day. Can I have a second?
Officer Evans, second.
Officer Evans, second. All in favor will say aye.
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 Happy New Year, everybody. And for you legislators on here, good luck in session. Hope it goes smooth for you.
All right. Have a good day,
Y'all have a good
everyone.
one.
Thank you.
Meeting's adjourned.